Hello, everyone. Greetings. My name is Rachel Sedlak, and I'm an undergraduate in the GMU Forensic Science program, and I'm honored to introduce to you the following speakers today. First, we have Amy Ailey. Next, we have Ken Melson, who has served the federal government for many years prior to leaving government service for the General Counsel's Office at U.S. Postal Service Office of Inspector General. Prior to that position, Mr. Melson served as the Senior Advisor on Forensic Science to the Office of Legal Policy in the U.S. Department of Justice, as well as Acting Director of the Bureau of Alcohol, Tobacco, Firearms, and Explosives. United States Attorney and Director of the Executive Office of U.S. Attorneys. In addition, Mr. Melson has served as co-chair of the Subcommittee on Forensic Science, Committee on Science of National Science and Technology Council, past president of the American Academy of Forensic Sciences, and a board member of the American Society of Crime Laboratory Directors and Laboratory Accreditation Board. Next, we have Professor Laurie Kornbauer of Brooklyn Law School, who works for Suffolk County, New York, District Attorney's Office Conviction Integrity Unit. She teaches trial advocacy and authored a section of the DOJ manual on violent crime on intentional murder. Prior to this, Professor Kornbauer was an assistant U.S. attorney for the Southern District of New York. She mainly prosecuted violent crime cases and cold case homicides. During that time, she also served as chief of the Violent Organized Crime Unit and special assistant to the United States Attorney, focusing on cold case and wrongful convictions. Professor Kornbauer was chief trial attorney in multiple murder trials and numerous prosecutions on violent crime and murder cases. Please do wait for the microphone for questions and enjoy the panel. Thank you so much.
All right, how's everyone doing?
Yay! All right, I like that. It's really my pleasure to kind of continue some of the conversations that we started yesterday about admissibility issues. I think there was a great question from the audience asking about whether different state courts seem to be ruling differently on some of these admissibility issues, particularly in forensic science. You'll get to hear about some of those cases in Laurie's presentation. But before we get to that, I'm excited to again welcome Ken Melson. He'll be laying the foundation. He'll be talking about some of the history of Frye. He'll be talking some about Daubert. He'll be looking at sort of where some of the states are. Spoiler alert, the trend is towards Daubert and away from Frye, but it's a little bit more complicated than that, as Ken will discuss. He'll also be touching a little bit on Federal Rule of Evidence 702. As probably some of you know, there are likely changes afoot in that rule. We will not likely spend a whole lot of time on that today, but if that is something that is of interest, please seek out Ken. I'm also happy to talk about that a little bit offline. So with that, I will turn the stage over to Ken Melson, who has a PowerPoint and will be starting us off. We also will be encouraging questions once these folks get through their PowerPoints. We obviously have some things that we're ready to talk about, but again, it's more important that we're addressing the questions that you have. So Ken, take it away.
Thank you very much. Good morning again. I can tell you after this lecture from Dr. Milner that there is a 95% chance that some of you will understand what I'm talking about. Now, did I transpose something that? But anyhow, I think you will, because this is just a primer on Frye and Daubert and the rules, because I'm only going to go for a portion of the next half hour, so we can save the very last portion of our discussion after Laurie talks to talk about how we deflect PCAST challenges to our evidence in court. So I'm going to go through this a little bit quickly. It's really pretty simple, but I'm going to talk about the evolution of Frye and how we got to Daubert. And one of the important things is to know that before Frye came along, and for many years after Frye, there were various tests for the admissibility of scientific evidence. In general, most of it all came in, and most of it was medical and other types of civil cases that were subjected to the review by courts. So you had the common law principles, which prevailed for a long time in our country, particularly in state courts. You had a commercial marketplace test, which some said that's what Frye really was doing is this something that's good in the marketplace? And if it is, then it must be okay for court. And the third is statutory, which was really interesting because in this particular case, of Yates versus State. I have to put my glasses on to read this. The opinion of experts on any question of evidence, skill, trade, or like questions are always admissible. Now, that's the one I like, but that statute didn't last very long. So along came Frye in 1923. This defendant, Frye, had appealed his case to the Court of Appeals for the District of Columbia. And he wanted to present in his own trial the precursor to the polygraph. And the trial court did not allow that evidence. He appealed it to the appellate court. And that was the issue for the court to decide whether it was scientifically valid enough or generally accepted in the community in order to be admissible and to remand the case for a new trial. So the court started talking about initially, somewhat of the general rule for admissibility. And that is when the knowledge that is at issue is beyond the common knowledge of the juror. I like to say beyond the ken for obvious reasons. My first name is Ken, get it? That was one of the things they talked about, which was general, but it also requires a specialized experience or specialized knowledge. So they're talking about the expert. And if those two are met, these opinions on four types, a science, art, or trade are admissible in evidence. Now, Frye became relatively restrictive after many years of discussion about it. Originally, it's limited to novel cases, novel scientific evidence, because as you see here, it talks about the transition of a technique from the experimental stage to the accepted stage, the proven stage among those in the community that are aware of that. So this became the general acceptance test. In other words, it's admissible if those who are in the field accept it as a reliable technique. Now, notice a couple things where it says the thing from which the deduction is made. Well, thing is an object, and that's what they're talking about here, the precursor to the polygraph. So they say if this thing is accepted by those in the field who use it, then it's going to be admissible in court. So it's a general acceptance. And what it really did, besides restricting it to novel evidence, it also gave the power to the admissibility issue to the scientists. And they decided for the court, really, whether it was admissible or not. All the court had to do was count noses. How many were for, how many were against. We don't know what the test was. Is it 51%? Was it 80%? What it is. We'd have to do a statistical study on that, I suppose. In any event, courts later determined that they had to expand the test in Frye from just general acceptance to some sort of evaluation of reliability, because experts in the field could generally accept a technique that was not valid. So just counting nose wasn't enough. You had to determine some reliability. And as Frye evolved, you will see that more and more states actually added those requirements. And I guess I won't probably have time to go through this a lot, but it's interesting to note that for the first 25 years, there were only 6 Frye cases, 6 cases that mentioned Frye. And most of those were civil cases or the polygraph. And 1950s, there were only 20 cases. Things hadn't progressed. Most of those cases were polygraph cases. In the 60s, there were only 21 cases. So, Frye wasn't catching on very much during this period of time until the 70s, when they had about 100 cases talking about Frye, and crime laboratories were becoming pervasive in the United States. There are disciplines that they wanted to introduce into courts. So the Frye was beginning to catch on. There were no federal rules of evidence at that point. So what was there to be guided by? Just Frye. Many thought Frye was a federal case, so they followed it. In 1975, however, they did develop a federal rule of evidence 702. That's when the federal rules were adopted. And you can see here that it's a relatively simple rule compared to the Daubert successive rule passed in 2011. But even after the Rule 702 was developed and passed, the cases in like 1978, Reed versus State, they said almost every court that determines the admissibility of scientific evidence uses the Frye test. So they really didn't incorporate the rule of evidence for what it was worth into Frye or their admissibility determinations. In the 1980s, there were 470 cases. In the 90s, between January 1st and June 28th, when Daubert was decided, there were 330 cases. The Frye case had been really criticized for a long time. And you can see in the Christofferson case that even dissent in the Supreme Court said we ought to leave Frye and go to the federal rules. So there was a lot of pressure on the court to decide that. You can read these slides later with respect to the proponents of Frye thought that Frye was good at determining uniformity in the acceptance of evidence, that it shielded the jury from new evidence that they might think was infallible when it was not. It avoided complex, and this is funny, complex, expensive and time-consuming courtroom dramas. Well, we know from Daubert that we have a lot of those, even though most of them are pretrial. And it insulates the adversary system from the abuse of novel evidence. And here are some more that you can read later, but one commentator said, Frye was perfectly suited to the court's competence. They only had to count the noses. Daubert now requires the judges to actually make a decision about it. How did you establish it? It was easy: general acceptance, expert testimony, scientific and legal literature, and judicial opinions. And you'll see I've got cases that support most of what I'm saying. There are a lot of criticisms of Frye as well. What's the relevant field? How many do you have to have in order for it to be accepted? What is the technique that you're looking at? See, Frye looked at the technique, and other courts looked at the expertise of the expert, not necessarily the reliability and validity of the technique itself. There are a lot of criticisms of Frye. So eventually, courts began to move away from Frye, particularly after Daubert had been published by the Supreme Court. And the last state that has, not the last of the Frye states, but the last state to convert from Frye to Daubert was a New Jersey case in 2023. So it's very recent. You ought to read that case because it helps you understand Daubert, and it helps you understand why Frye was not necessarily a good standard for admissibility of scientific evidence. But you can see there a couple things interesting. They said, well, we've been going with Frye for a long time. How can we reject our precedent and all of a sudden jump to Daubert? You know, that may sound familiar in some of the Supreme Court cases we've seen in the last year or two. Well, they say you have to have some special justification in order to reject years and years, since 1923, those types of precedents. But they said in this case, there was a special acceptance, special reason to do that because of the enhanced ability to analyze forensic evidence, which was so important in so many cases. But they declined, New Jersey, and not surprising, declined to accept all of the Daubert judicial decisions. Since then, they're going to work on their own, and importantly, that it was not retroactive. All right, so this is a diagram of the states that are Frye and the states that are Daubert. You can see we've updated it, and there are only 6 states now that do Frye. Now, what time am I doing? Am I going 5 minutes? Okay, so one of the things I think that's important to remember when we compare Daubert and Frye is that Frye evolved. It evolved from just a novel technique and general acceptance to a determination of reliability. And you see around the United States before conversion to Daubert that those Frye states really started to adopt various tests to determine reliability and validity of the underlying technique or scientific principle. You see many of them saying, okay, now we're a Frye state, but we need to determine reliability, and they're adopting in their reliability tests the Daubert factors. So it was all moving towards Daubert for a long time. Here are 4 examples that you can see from various states. I got them from California, Minnesota, Illinois, and DC before they converted to Daubert. The various tests that they had. So there really, I don't think right now, much of a difference in the bottom line analysis that you do in either one of those states. So then came Daubert, and I only have a minute. That was the Benedictine case. It was a civil case that now produced the Supreme Court case that guides us in criminal cases as well. They expressly said it superseded Frye, and the judge now is the gatekeeper instead of the community of experts. Some things that are important to remember about that is they expressly say that the rules of evidence on admissibility have a liberal thrust. You know, they have a liberal thrust. There should be greater ability to introduce evidence now than before. And the focus is on the techniques and the principles, not the conclusions that they generate. And what is very good, I think, to argue for the courts who are looking for ways to allow this evidence is that the vigorous cross-examination and presentation of contrary evidence and instructions by the court are the normal way for the jury to evaluate evidence about which there is a dispute. So Daubert came out with a couple general observations. You can read them here, and we'll talk about those later. But let me just say that these are general observations. That's a quote from the court. They aren't, and they're only factors. They're not required in every case because not every case can discuss or has a basis for one of the Daubert factors. So don't get lost in the fact that each one of these have to be proven. And this is 702, which was passed in 2011. It really kind of adopted it all real quickly. You have to have a qualified expert. It has to be helpful to the jury. You have to lay the foundation for your evidence to make it relevant for the court. You have to have a reliability and validity determination, and it has to be properly applied during the testing procedure. So those are the Daubert things that we'll talk about when we're discussing the PCAST influence on Daubert cases. So next we have Lori, who's going to, yeah, there I am. I've already introduced you, Lori.
Thank you so much for bringing that.
But this isn't your presentation yet.
So we get switches into the PowerPoint. And while we're doing that, you know, just to sort of reiterate some of the things that
No.
this is much more about
Does it work?
the science.
No, he's got to bring it up.
So much on the application by a particular expert of those techniques. So that is obviously something that the prosecutors will have to eventually litigate. But it's sort of these big sweeping questions about the science itself that we're really focusing on today. And you know, one thing as this is getting loaded, and now it's loaded, so
I think it is.
Lord yours.
Thank you, Amy, and thank you, Ken. I want to talk a little bit, not so much in great detail about the PCAST report and what it has sort of resulted in both the state and federal courts. I will preface this by saying I'm using a PowerPoint that was primarily created by Amy. Because I always tell my boys, never take credit for something you haven't done. It's kind of cringy. And you will see when we get to the end of the PowerPoint, those very crude slides are mine, which will demonstrate with 100% statistical certainty that you should never allow me to make the PowerPoint. So anyway, in 2016 is when the report came out. It was commissioned by the Obama administration. And it really was, this is the report, this is what it's called. And what it announced new standards to determine if forensic science disciplines are foundationally valid. There is a definition of that particular term in a case that I will give you later, because I am not familiar with that term myself, and you may not be. And if a particular expert in a scientific discipline should be permitted to testify. These sort of things were not really scrutinized all that much before the PCAST report. Although I do recall being from the Southern District, that the first real challenges were to ballistics examinations and tool marks examinations. And we had a judge in the Southern District, Judge Rakoff, who really started the ball rolling on that and started challenging what the experts could say. And we were pretty stunned at the time that this was even being questioned. And so after that, the PCAST report came out. These standards were applied to a number of disciplines, but I think what we're seeing, the trends in the court is, in the courts are mostly, to a great degree, again, ballistics challenges. That's not really very surprising because in most murder cases, many murder cases, guns are used and there is ballistic evidence. So we see a lot of those challenges, as you'll see pretty soon. And also the report made recommendations to federal prosecutors and judges and federal agencies about how we should be scrutinizing this kind of evidence. Okay, so foundationally valid means DNA analysis of a single source and simple mixture samples is foundationally valid, as are latent fingerprints. And those are really the only two that the report really said were definitively foundationally valid. Not foundationally valid, many others. DNA analysis of complex mixture samples, which we're seeing a lot more of today. Firearms identification, which impacts on so many violent crime cases in the country. Bite mark or forensic odontology, footwear analysis, and hair microscopy analysis. So those are not, according to the report, foundationally valid. Yep, sorry, I'm not great at these PowerPoints. So there's a breakdown. We did a breakdown of the PCAST decisions over all disciplines. And again, you can see there are many cases discussing PCAST, over 100. We did reduce these cases to a very sort of nifty spreadsheet. Amy will tell you where you can get that, describing the cases, the decisions, breakdown of a lot of granular information that might be useful to you. I will tell you that since that chart was made, or since the spreadsheet was made, there have been more recent decisions, and I'll talk about those a little bit later. Those are my crude additions to this PowerPoint. So you can see here how they're spread across all the disciplines. And again, firearms and tool mark by far are the most cases. And this is just a breakdown geographically of the courts issuing the PCAST decisions. I think mostly in the Northeast, we're seeing most of the cases, and out of California as well. And this is just a breakdown of the courts that have the most decisions. Again, I think everybody knows this intuitively, that when you're looking at this kind of information, you need to go to the court that you're dealing with, because the courts have not been entirely uniform in the way that they are dealing with PCAST and the weight that they're giving the conclusions in that report. So always, always go to the source. again, the firearms decisions, pretrial, a lot of decisions pretrial. Mostly what the courts are doing, I just want to actually quote what I think is really some of the most important language from the PCAST decision, where the report says, from the standpoint of scientific validity, experts should never be permitted to state or imply in court that they can draw conclusions with certainty or near certainty. We're seeing that in the firearms decisions. The courts are not liking language such as it's a definitive match, it's 100%. So even if you have a great deal of belief in the accuracy of firearms and tool marks analysis, especially in that area, you have to really be careful of what you're going to elicit from your expert. There have been appellate decisions as well, post-conviction, just a few, mid-trial, again, just a few. So there were 3 federal courts of appeals. Now I am actually going to add, there are 2 additional cases that you'll see at the end of the PowerPoint. So there are actually, I want to see what these courts are. So there are 2 very recent federal courts of appeals decisions. And these decisions tend to be very most of the recent decisions, again, are firearms. I think there's a bite mark. And I think there might be a fingerprint decision that's pretty recent. But they do tend to apply a very granular Daubert analysis. I haven't seen a Frye analysis in any of the recent cases anyway. So you'll see from the 7th Circuit, from the 9th Circuit, there's a recent decision from the 10th Circuit, a recent decision from the 11th Circuit, and from the 2nd Circuit, which I think may have even come out of one of Judge Rakoff's decisions. And the federal courts seem to be giving us considerable weight, I think more than the state courts, to the PCAST report and its conclusions. This just tells you what the state of the law is in terms of the appellate decisions. Most of the courts are affirming. Most of the courts are limiting the language that the expert can use. And that can take various forms. Again, you need to look to your particular court to see what language the court prefers and to try to cabin your expert, I think anyway. Ken may have a different view of this, but I think when we talk about how to sort of bat back some of these challenges, we'll talk a little bit about the language. I'm going to skip past some of this only because I think the discussion on the cases and sort of on how you need to be looking at this before you put your expert up is more important than this. There are some state court decisions as well. There are some reversals. Most of the reversals that you're going to be seeing in the federal courts anyway are instances where the firearms expert said something like, that is 100% match. I'm absolutely certain. It's to a scientific certainty, instead of sort of limiting that language. The courts are not liking that. And that really does go along with the language that I read to you from the PCAST report. Okay. I want to just skip past some of this stuff that is not particularly, it's not that it's relevant, but I don't think it's something that we need to really bear down on today. There are a couple of civil cases. Most of the cases are criminal cases. Not surprisingly, in the firearms decisions, almost all of them are. As far as fingerprint evidence, the courts are, again, very much in favor of viewing that as a very reliably established science. So there's not really that much of a problem in terms of PCAST when it comes to fingerprint analysis. Bite mark is is quite different, actually, at least when it comes to things like saying that a particular bite mark is a match to a particular set of dental records. It gets a little bit problematic in those cases. We do like our firearms decisions, don't we? So here's just, again, just a breakdown of what the courts are doing. And you'll find cases probably from every district across the country. Okay, fingerprints. There have been a number of cases. Several federal fingerprint decisions excluded defense witnesses who would have testified about the PCAST report. So again, the courts are not necessarily saying that a defense expert can testify about the PCAST report. Most courts are allowing cross-examination based on the PCAST report. You need to look to the cases and what the courts are saying, because there is a lot invested sort of in the history of these forensic sciences. And I think the courts are mindful of that. And this is sort of like a new horizon, the PCAST report and some other reports as well on the federal level. DNA, again, a single substance DNA analysis is going to be pretty much admissible, foundationally reliable. There have been a number of cases in federal and state courts. One post-conviction case. There are, some of these tend to be in the older cases as well, so they can be a little bit of sort of like outlier cases. Okay. This is just a breakdown of the fingerprint and DNA cases in the federal courts of appeals. Again, I would point out those two very new cases out of the 10th and the 11th circuits, both of which I'll repeat again, have very granular and very helpful Daubert analyses. Bite mark, there are 4 state appellate post-conviction cases. Footwear, there are a couple. The presence of semen, I think we found 1. Ink dating, we found 1 out of the Southern District of New York. And again, these cases are still being decided. I was a little bit surprised to see really that the courts are still very much using and relying on the PCAST report and referencing it. So this is sort of like a little, this is a picture of the chart that I talked about before. I don't think this is interactive. Am I right, Amy? But Amy's going to tell you where you can find an interactive version of this. It has a lot of very helpful information, and will give you a snapshot of your particular district or your particular state and what's going on there. It's broken down in terms of disciplines, I believe. So you'll find all the firearms decisions and then the DNA decisions, and it'll follow in that way. And so you'll see there are descriptions of this. You can navigate through this so that you see descriptions of all of the cases. And here are my sort of, these are my crude sort of like slides. These are the most recent cases, several federal cases. There's the 10th Circuit case and the 11th Circuit case, which are, they're both favorable to the prosecution. They're not, I think the Hunt case is a little bit of an outlier. I don't know what CMS firearm analysis is. Does anybody here know what that is?
Robert does. It's a way to objectively measure the similarity of striated tool.
So you don't really see that analysis very often, according to this case anyway. And so the court distinguished that from other tool mark analysis that we see more often. So those are the federal court, circuit court cases. Here are some federal district court cases, and there are a number of them, and state cases as well. And I think that most of these are pretty self-explanatory, although we might point out a couple of things when we're talking to you more in detail about the cases and about the challenges to admissibility. And I think we should just go into the Q&A.
Great, thank you. So I'll just add a little bit of additional context. So I expect you heard from Rob Thompson this morning a little bit. You'll hear from him again tomorrow. He'll be able to tell you about how there are new, and by new, I mean post-2016 when the PCAST report came out, firearm studies that really do solve some of the issues that PCAST pointed out with regard to the reliability or validity of the field. So I'll just commend you to listen to his wise counsel on some of the additional data that's available. It's also important for the cases that we've gathered, which are about 101 that are in that chart that Lori put on the screen. Those are through around mid to late 2022. We're seeing if there's a way to get those updated. So, and those really are only the cases that we know about, right? They're the ones where there was a written decision that was either picked up on Westlaw or Lexis, or actually published in a reporter, or where a member of the community sent a decision to us or sent a transcript to us. So when we provided a similar talk that I think some of you heard through the Forensic Technology Center of Excellence, I was broadcast last week. One of the questions that we asked there was how many people knew about additional kind of post-2022 PCAST studies or PCAST decisions, that is admissibility decisions about forensic science, and something like 75 of the 260 people, again, statistics, pause for laughs, which never come. But that gives you an idea that, you know, we only sort of know what we know, but the idea is to sort of give people a snapshot. As Lori said, for the firearms tool marks, there's a range in how the courts are addressing those. For some of them, if the prosecutor says the witness is only going to talk about what is permitted by the US DOJ's uniform language for testimony and reports, the judge says, fine. Sure, go ahead, witness. There are other times where the courts say, you know, we're going to limit what it is that the firearms tool mark examiner can say. And they're really the devil's in the details. If you feel like what your case needs is for your expert to say that gun shot that bullet beyond all doubt, you may not be able to get that. But I think that makes some of the points about what Chris said, what you're hearing from other people about just the need to work up your cases fully and thoughtfully, ever the more important. You shouldn't be hanging your hat, if you can, on any one piece of evidence, whether it be forensics, whether it be a witness, just to do the work that I know you're all doing every day to work up your cases, just as you heard. I now see Jeremy. Jeremy, would you raise your hand since you didn't actually get a talk on it? So this is the person who the judge had to pretend to be during our morning session. So if anyone has any questions for Jeremy about the case, I'm sure you'll see him on the breaks. So
let me just say one thing. And based on the more recent cases, it is, in my view anyway, based on the cases, you are very highly unlikely to get in that absolute definitive language.
Right.
I'm just, so it's something that you need to be mindful of. Don't hang your hat on that 100% match, because you're likely not going to get it.
Yes, great point. So I'd love to sort of open it for questions. I can also start by just throwing out, you know, we kind of talked about some big principles, or Daubert, Frye, 702. We talked about some discrete cases. Let's talk a little bit more on the ground about how we should actually go about litigating these cases. What are some of the things, Ken, that you're thinking about when you're
Since I have the computer up here, let me stand up here, but I'm relying on these two young ladies to actually give the substantive information. I put this PowerPoint together for purposes of going through preliminary issues and all the Daubert factors, and just pointing out some things that you may think about in order to rebut the challenges from PCAST. I put citations under each one of those, so you don't have to go looking for a case that says that. You can start your research by reading the cases that we've cited there. So first, we can open it up to questions about the PCAST challenges if you want, or we can pick and choose as we go through the several pages of ideas. Do you have any questions off the bat here? All right, well, let me point to one thing that I think is important, and that is on the preliminary issues. What page is this? Page 3, is that you don't always need to have, you don't always need to have a Daubert hearing. And if you look on this, when you get it off the internet, you can see that there are cases that say, well, we don't need a Daubert hearing in this case because we've already decided, our Supreme Court has already decided that, or another court in the jurisdiction that is persuasive has already decided that issue. So unless there's a new issue regarding the particular discipline, you may not need to have a Daubert hearing on that particular subject. Do you have any comments on any of these others?
Well, I do think that that's true. And you will see the courts saying, I know what these issues are. I don't need to hear from anybody. And they will, because it's the same factors that are being applied in case after case after case. The Daubert factors don't change. And there is a lot of information out there and a lot of good analysis that is already available. So if you are teeing up for a Daubert hearing, if you're having one, there's plenty of guidance out there about what you're going to need to do. And not every hearing, I don't think, focuses on every single one of the factors. The courts may mention them, but there will be ones that are more relevant to your particular case than others.
And most of those focus on the relevancy, the validity and reliability of the issue. I pulled up this one because one of the Daubert factors is, can it be tested or has it been tested? And the PCAST used the black box. They said you have to have one or more of the black box studies because only they are the ones that can tell us the real error rate of the experts in this particular discipline. But what's been argued and shown definitively, and courts have adopted it, that since PCAST, there have been other black box studies. So the forensic community, just like with the NAS report, although they didn't like some of the descriptive characteristics of the particular disciplines in PCAST, they've taken the initiative to go forward and say, okay, you want a black box study? Here it is. And so one of the most effective ways to combat this is to show that there are other black box studies and you've satisfied PCAST. And you're almost done at that particular point.
And Ken, with respect to the studies themselves, something I've seen repeatedly in the decisions is whether inconclusives should be counted as negatives or as nothing. And I'm sure that the statistics would change greatly because whether you allow somebody to mark an inconclusive as yes or no, and courts are looking at that issue and coming out slightly differently on it. So if it's important to your case, you should definitely bear down on that.
Well, it will be important in firearms cases. Other cases, it may or may not be, depending on the studies and how they interpreted the particular statistics. But here I've cited a couple cases here that actually go into and talk about the benefits for one side or the other, whether you include it inconclusive as a correct answer or not a correct answer, and how that affects the outcome of the statistics. But it's also important to know that with respect to error rate, maybe on this slide, yes, that they kind of give us an inference that error rates that are less, and hopefully far less than 5%, are okay with PCAST. And you have to remember when you're talking about PCAST that the PCAST members, this is a presidential team of people, none of whom were forensic scientists, not a single one. But they did have a review team that looked at the report. And guess who they were? Judges. They weren't scientists. They had people just like in the NAS report where they came up and would testify about this or that. But when concluding and evaluating and writing the report, they had no forensic science on it. So you have to remember that as well as far as going to error rates. And I think there was a court here that actually indicated that, it doesn't have a lot of deference to us because they didn't have any forensic scientists on it. And you can always argue in any of these cases that error rates, which are the primary attack, really go to the weight of the evidence and not the admissibility of it. So that means you go back to the Daubert case and say, well, look at what the justices said, that cross-examination, presentation of countering evidence, court jury instructions, those are the things that in the trial itself you can use to counter the PCAST report. So it's,
Right,
remember
so
that approach as well.
5% that PCAST sort of said was okay, the 5% error rate. That's not the sine qua non. It's not like that doesn't start or end there. That's just sort of like something that's sort of like a reference point that you can get. And I will tell you that the brand new case of US versus Ware out of the 11th Circuit, it's 69 F 4th 830, talks about error rates as being subject to cross-examination and going to the weight and not the admissibility of the evidence. Although that wasn't a fingerprint case.
Right. And I guess maybe just taking a step back from the factors themselves. I mean, one of the big takeaways that I think we want everyone to leave with is understanding generally what is out there, whether this is the PCAST report, whether it is something else that is circulating among the prosecution community, among the defense community. Sometimes, I think motions sort of get passed around, but sort of understanding what is happening in your district is really important, and understanding what is happening with your scientists is also very important. How many people are actually sitting down and prepping with their experts before trial?
Everyone.
Yeah, I mean, I know not everyone's a prosecutor, so not everyone's hand is going to be going up, but that's one of the fundamental things, making sure that you understand what your expert is going to say before you put that person on the stand is extremely important. Making sure you understand the limits of what the expert can say, either because of the science or because of the particular case, is extremely important. And making sure that you're carving out enough time to not just know how you're going to put the person on the stand for your direct, but also the questions to ask on redirect once something's been kind of mucked around is also really important. And it takes time, it takes some time to get up to speed on the science. And those of you who are here today and yesterday and tomorrow and Friday, obviously you have put in the commitment to do that. So that, is an extremely important first step. And, one of the big goals, I think, speaking for I'm no longer part of the NIJ National Center on Forensics, sadly, but speaking for, I think some of the people who are, we want to make sure that people have the tools to find what they need to find when they need to find it. And that's where knowing Chris Kelly, getting to know Rob Thompson, Marna McClendon, raise your hand, Marna, is also a great resource. And I'm more than happy to even, in my current job, kind of put people in touch with folks who can help them get up to speed on the science, help them get up to speed on some of the techniques. So that's a little bit outside of just the sort of core admissibility principles, but it's just a very, very important thing for all of us to take away. I think it's true for our detectives as well, right? Understanding that maybe, you shouldn't expect that your firearms tool marks examiner is going to be able to say, yeah, that gun shot that bullet, I'm 100% sure, can help inform the sorts of decisions that you need to make to, again, shore up that investigation. So it's a little outside of the factors.
Okay, we have a question out here.
I do have a question. So the PCAST report was published in 2016, and it's now 7 years ago.
Yep.
And they made some conclusions about things that were foundationally invalid, right? Correct. I mean, I haven't read it. So, and for example, one of the things was hair testing.
Correct.
And obviously we've made a lot of significant advances in hair testing since then. So does it account for the fact that things might change with scientific advancement?
Oh yeah, I don't think the report is foreclosing.
I mean, yeah, it's like for firearms tool marks. And again, I know Rob will be able to talk about this a lot tomorrow, but the PCAST folks decided there was just one good study. And they said, well, if there were 2 good studies, then it would be okay. And now the community has sort of provided a lot of really thoughtful studies. So I think even, and I hesitate to speak for Eric Lander, who is sort of the father of the PCAST report. I would not purport to do that. He certainly wouldn't want for me to do that for him. But, I think there was an acknowledgement that at least for some of these sciences, it's not that the bones aren't there. It's that in the PCAST sort of view, that the proof hadn't yet been established. So, but there are also things like bite marks that PCAST suggested are just never going to be able to rise to the level of individuation. So, but there are some sciences certainly that they sort of recognize could evolve.
Yeah, just real quick. Oh, excuse me. Sorry. One thing is that I don't know if this could be considered. It's advisory. The report is advisory. It's an important group. Not to dismiss that at all. However, I don't think this would be considered a scientific treatise.
It's true.
And even then, most journal articles, scientific research gets peer reviewed. While there was no peer review on this, there were a number of responses back from professional societies picking out things that might have been missed or might have been misconstrued, or maybe even supported some of it. So I would advise people who are looking at the PCAST report, also look at the following peer review, if you want to call it, of organizations who had comments. And I think those are just as important as the PCAST report.
And if you look at the bottom of my presentation here, I've listed up, for some reason it left me. Did I what?
All right. Well, while
In any event, at the bottom of the presentation are the PCAST responses from the various forensic science organizations and the Department of Justice and other federal laboratories.
Right. And
so
while there isn't a published, Attorney General Loretta Lynch, who was the Attorney General at the time, said, you know, thank you very much. We're not going to be following your recommendations to not introduce this testimony, but, you know, appreciate your comments. So I think that that's an important point. Those are also some of the points that the courts have noted when they do things like exclude defense witnesses who would purport to testify just about the PCAST report. And the slides for a couple of the fingerprint cases on the federal side, you'll see that that is the sort of decision the courts made. In the NIJ and CF sort of PCAST extravaganza chart that's available online. You can also sort, as Lori intimated, by discipline. You can also search for expert names. So if you have an expert who's coming in either as one of your experts or as an expert for the defense, to the extent that those opinions have actually listed the names of the experts, you'll be able to see if that expert has been mentioned in an opinion in this space. We also have information about what the courts did, in as much as things like either limiting, for example, firearms tool marks examiners' testimony, or in excluding defense experts who would be purporting to testify about the PCAST report. So that is a resource that, you know, continues to be available even after we all go home, hopefully with flights that are a little bit less complex than for some of us, the flights that got us here.
We have one more question over here.
I think Amy just answered it. So the thresholds for defense counsel who present information would be the same thresholds that a prosecuting attorney would have in terms of introducing information that's considered valid.
Right. Yes, with an asterisk is what I would say. I think that the same tests apply, but I think sometimes courts can look a little bit differently. But that's more of a lunchtime or perhaps, you know, at a bar conversation than one from a panel probably.
And I'm surprised that forensic pathology in some ways wasn't included in that.
Right. And you know, bear in mind also that nice little nugget in the PCAST report where the authors themselves say, we're not displacing the courts. This is still a function that belongs to the courts, okay? Yeah. And so if you have somebody who tries to rely wholesale on the PCAST report, that's a pretty quick and very effective response. The other thing I wanted to point out from a practitioner's point of view, from a trial attorney's point of view, if you have that sort of like recalcitrant and stubborn expert who says, I cannot testify any other way than this is 100%, that's what I believe, et cetera, it's all in the trial prep. And it might even be something that you would raise before trial to the defense counsel and to the court and say, look, I'm going to have to lead this witness in a way that is going to be quite leading in order to prevent that witness from saying what you don't want that witness to say. And nobody is going to have a problem with that, right? That's helpful to the defense. The court is going to like the fact that you are respecting the ruling and trying to abide by it. So that's just sort of like a practical way that you can deal with that.
And also prep with your witness if you're going to be doing that, because you don't want there to be some sort of, you know, display of difference before a jury.
Individuality.
Yeah.
That's the comment you guys are saying. I think if you ask your expert that they're 100%, just ask them. So you're saying that you have no error. Basically, that's what he's saying.
We're going to have a metaphysical discussion or something now.
You know, and as scientists, we know any measurement has error.
Right.
It doesn't matter what the measurement is, it has error. So,
right.
So you just ask them pre-trial, are you going to say that? They would probably then say, whoa, okay, hold on.
That's
Like-
probably just a product of like years
Yeah.
and years and years of saying that, right? So they're used to
Right.
saying that.
Right.
Yeah, just
Right,
kind of
and I
check
think it's
them.
possible prosecutors have gotten this wrong in the past and have pushed their experts to be even more and more sure. And, you know, at the end of the day, we're officers of the court. Our job is to sort of not over promise, not under promise, really try to reflect ground reality within the confines of these legal requirements, which is pretty awesome, but also means that things like understanding the limits of the science are arguably somewhat of an ethical duty, as well as just a practical, you know, good practice. So I think, and I realize it's really obnoxious to say once you finish talking, and not giving your panelists a chance to have the last word, but I also know that we have a very tight ship, and it is noon. So I will ask you to thank the panelists with me and then head on to work.